of business disputes are continuously changing over time. If you do not keep up to speed with the changes, then your case may severely be affected. One of the most recent additions is the pre-action protocol for debt claims, and that is what we're going to be discussing in this video. Pre-action protocol for debt claims came into place on 1st October 2017 and relates to all business to individual debts. So that means that if you are a business, whether that's a limited company, partnership or sole trader, and you're pursuing a debt from an individual, but that also includes sole traders as well, then you'll need to follow the debt procedure. The pre-action protocol is there to encourage parties to seek to negotiate matters to a settlement rather than taking matters to court. It promotes early exchange of information and documents. It encourages people to speak about the issues and try and reach a resolution without it needing to go to court if at all possible. If parties do not follow the pre-action procedure, then there may be sanctions. If a creditor takes the matter to court and has not followed the pre-action procedure, then the court can stay matters. It can issue directions to put the proceedings on pause so as to enable the people to go away and follow the pre-action procedure. But it also may issue cost sanctions. So that means even if a creditor is successful at trial, then the debtor may stand up at the end of the trial and say that they want payment of their legal costs because the creditor failed to follow the procedure, and therefore the logic being that the debtor would say that costs have been wasted by taking it to court, where otherwise, if the procedure had been followed, the matter may have been settled. There are various steps that a creditor and a debtor need to take in the pre-action procedure. The first one relates to a creditor. They need to send out a full and detailed letter of claim. In that letter of claim, they need to set out all the information that a debtor would need to assess the position. That includes how the debt has arisen, how much the debt is, whether there are any interests or interest elements to be paid, whether it was by way of a written contract or an oral contract, and if it was a written contract, all of the documentation with it. The debtor, upon receipt of the letter of claim, then has 30 days within which to reply. The debtor can choose to use the reply form, which needs to be included in the letter of claim, and on that reply form they can admit the debt, they can dispute the debt, they can ask for more information, or they can advise that they're going off to seek independent legal advice. If they want more information and the creditor is obliged to supply it, if the debtor wants to go off and seek legal representation, then normally they get another 30 days within which to respond from the last day in which they ought to have responded to the letter of claim, which is in itself 30 days. If the debtor does reply but asks for more time to pay, then normally the creditor and debtor are expected to go through a period of negotiation to try and reach a settlement before it goes to court. If those negotiations fail for whatever reason, then the creditor must put the debtor on notice of that failure, and also to put them on notice that in due course, normally 14 days at the very least, that court proceedings will be issued against the debtor unless full payment is made. So if the letter of claim has been sent and the debtor has responded, but ultimately an agreement has not been reached between the creditor and the debtor, or the debtor has not responded at all, then the creditor will be entitled ultimately to issue court proceedings against the debtor. Both parties always need to bear in mind alternative dispute resolution. That effectively means any forum within which negotiations can take place. So that means correspondence, telephone calls, without prejudice meetings, but also formal ADR, as it's called, alternative dispute resolution, which is mediation. So a court would expect people to at least consider going through one of those processes before taking it to court. At Astor Patterson, our experienced lawyers are here to help you in your business dispute. To learn more, please contact one of our experts today.